Good day and welcome to wherever you are in the world today. I'm very pleased that you've joined our webinar today. Our webinar will be on restructuring in 2021, navigating the landscape post-COVID and Brexit. Thank you for joining us. My name's Andrew Petersen. I'm a finance partner in Alston & Bird's London office. I will be moderating today's webinar. And we've put together a fantastic panel for you today. Your panel today are Giulia Battaglia, partner at Chiamenti in Milan, Inigo de Lusa, partner at Quattrocassis in Madrid, Jean-Gabriel Frandois, a partner at Gide in Paris, Eva Rudelhuber, a partner in Gleiss Lutz in Frankfurt. We also have Will Sugden joining us from Alston's Atlanta office from across the pond, and coming back to London, my fellow restructuring partner, Phil Taylor in Alston's London office. Just a few housekeeping points. This program is being recorded today. If you are listening to a recording, then our discussion is current and accurate as of February 11th, 2021. Some of this information may have changed as time passes. We have a large panel today, but please note the views and opinions expressed during this program are those of the panelists alone and do not necessarily reflect the official policy position of the respective firms on this call. If you have any questions at any time during the program, please do submit them via the Q&A button at the bottom of your screen. We are going to try and allow a few minutes towards the end of the program to answer some of those questions. If we do not get to your questions, then we will absolutely follow up afterwards with you direct as well. So we have a lot to get through today, and so without further ado, I wanted to kick it off as to why we're having this webinar virtually and not sitting in a room, in a conference room somewhere. Obviously, the reason we're having it virtually is because of COVID-19. One of my first questions that I wanted to put to the panelists is what practical effects are they seeing from COVID-19 on the restructuring market? What are we seeing on the ground? What level of restructuring activity are you seeing? What do you expect as a consequence of the pandemic? And if you don't get the level of expectations of restructuring that you're expecting, why not? So I'm going to direct those questions to Eva, perhaps. You're on mute, Eva. Thank you.
So I'm sorry, I was still on mute. Good afternoon, Eva, from myself. Thank you for joining. Yeah, the pandemic is a very difficult situation in Germany, as it is for all European countries, as it is in the US. We see a lot of restructuring activity at the moment, following the shutdown of the businesses, the partly shutdown of the economy. The German government decided to really step up and assist the economy in its fight for survival with 600 billion of subsidies. They are partly dispersed as subsidized loans, partly also simply by funds being provided to smaller businesses, and for the large businesses, the German state even becomes a shareholder in the business, such as in Lufthansa. So there's a large rescue plan, and these financings and these assistance programs are still going on. So there's quite some activity there. Nevertheless, it's not yet perfect. Disbursement of funds is sometimes late. So some of the businesses go into insolvency simply because they do not get the funds in time. So that is the current situation. Germany also has postponed or eased the filing requirements for over-indebted businesses to assist them in surviving the crisis, but still it's a very difficult position for most of the economies, except for those who really work into the pandemic, such as the health business, the pharmaceutical business. So that's where we stand at the moment in Germany.
Thanks, Eva. And obviously it's a global problem. Moving across to Spain, Inigo, what are you seeing on the ground there?
Yeah, good afternoon, everybody, and thank you to Alston for the invitation to this panel. Well, in Spain, for large groups and companies already in financial distress, COVID has accelerated the restructuring. We have seen this in cases such as Abengoa, OHL, Naviera Armas, and some others. So at the end, we face currently more complex and painful restructurings due to balance sheet deteriorations. For other groups and SMEs, thanks to the state financial aids, mainly through ICO and SEPI, we will discuss those later, and due to the employment legal measures and other legal provisions passed by the government, we do not see really deep distress restructuring yet. Seems that they somehow solved the liquidity issue for the moment. However, if the economic recovery is delayed in Spain, of course, we anticipate deep restructurings widely in many sectors in Spain during this year. Also have to say that some sectors in Spain have been particularly hit. I mean, retail, leisure, hotels, airlines, and we see attractive investment opportunities here. And also we see foreign investors waiting for the right time and situation, both in acquisitions and especially in lending. As a result of these corporate restructurings, M&A is now in Spain very active in all sectors, and this will be pretty much the broad picture at this point.
Thanks, Inigo. And obviously, you mentioned perhaps the withdrawal. We'll get on to the withdrawal of those stimulus programs that we've seen across the globe in a second. But Julia, maybe you can give us the landscape from the Italian perspective.
I think it's, hello everybody, thank you for inviting me to this panel. And I think the situation in Italy is very similar to that of the other European jurisdiction, in that there is clearly a deep distress in many sectors, as Inigo was mentioning, hotels, the leisure, retail, and so on. But in reality, the number of restructuring process and insolvency proceeding has decreased due to a number of measures implemented by the Italian government. So, for example, according to a survey carried out by the Bank of Italy in January, in 2020, the number of bankruptcy proceedings has decreased by a third compared to 2019. So we have 3,700 bankruptcy cases less than the 11 cases which were registered in 2019. And this is mainly due to a temporary bar on petition for bankruptcy, to a general slowdown in the activities of the court, and to the economic measures implemented by the government, such as state guarantee and state guarantees loans and statutory standstill and moratorium, as well as an exception to the general rule of subordination of shareholder loans. So again, restructuring and insolvency are going down. What we see is increasing, though, is distressed M&A and in general distressed investments. That's the general picture for Italy.
Thanks, Julia. Skipping across to France, Jean-Gabriel.
Yeah, actually, it's funny to see that we have exactly the same figure as you have, Julia, in Italy. Actually, the number of insolvency proceedings has decreased in 2000. If we compare it to 2019, in 2020, it has decreased by 1/3 too. So it's quite surprising actually to see the same effect. Although we don't have the same schemes, definitely we have similar measures in all of our countries. In France, the key aspect of the fight against the crisis has been the granting of state guaranteed loans. So it's last resort loans granted by the commercial banks, mainly by the French commercial banks, because the foreign banks are a bit hesitant to grant these. And you get a guarantee from the state up to 90% of the full amount, depending on the amount which has of the size of the company. Sorry. So this is the main reason certainly for that decrease, because we also had some provisions at the beginning of the crisis the companies were not obliged to declare what we call the cease of payment, so the insolvency status for a certain period of time. But this is now over. So if you are insolvent, you have to declare insolvency. But the fact is that for most of the businesses, they have found a kind of business as usual way of dealing with the crisis, dealing with the subsidies, with the furlough scheme, with the state guaranteed loans. So this is quite surprising, but the number of insolvencies has not increased yet by those days. What we can say is that it's very different from one business area to the other. Definitely retail, restaurants, hotels have been under high pressure. We have also seen a lot of pressure on LBOs and PE-controlled companies because the banks were hesitant to grant, even if there is a state guarantee, were hesitant to give more debt to companies with a high leverage. So this is the kind of transactions we've seen over the year, even for big tickets, but definitely that's each situation is different from the other. The last thing I don't know whether it's typical of France, but definitely the role of the state is a heavy role. The state is deeply involved in all the significant transactions and restructurings, and coordinating most of the negotiations together with the commercial court. So that's very, the state has done the job until now.
Yeah, thanks, Jean-Gabriel. As you say, we've not seen this coordinated state involvement in our markets since the GFC. Skipping across the channel then, obviously we saw a tremendous amount of central government stimulus go into our UK economy, Phil. With what impact do you think?
Absolutely. Well, I think the restructurings we've seen in the UK over the last year or so are mainly in certain sectors, the same sectors that, as have been mentioned by others, those being the ones that have been directly affected, if you like, by the pandemic. So the travel sector, tourism, services related to that. So we've seen Virgin Atlantic, Flybe, we've seen Swissport and Gate Group. Rental cars, Hertz and Europcar, and then real estate has been a big factor with people being less interested in the office market. Hospitality, with pubs and restaurants being closed, and bricks and mortar retail as well being impacted. So those things have all, as one would expect, taken a significant impact, and we've seen restructurings in those areas. But what we haven't tended to see are the enforcements. The banks are on the whole, banks and lenders are on the whole running around and being quite supportive, and the stimulus measures have also helped. So we're not seeing the levels of restructuring that one might expect from such a massive change to the economy. And I think that will. It remains to see how that will progress, and I think there's some challenges to face in 2021 as the pandemic continues. The vaccine rollout being a major factor, and as and when that happens, I think we'll also see enormous challenges when stimulus measures are starting to be withdrawn, and both from a monetary and a fiscal perspective, that will be really interesting. I think it's going to be difficult times ahead, and the other thing we're seeing, I think, it's a difference in pricing expectations, and that's leading to less transactions. So the restructurings that have happened are the ones that have needed to happen for liquidity reasons, effectively, and business reasons. So the more sort of opportunistic transactional restructurings we haven't seen yet, but I think those will come in the next year.
Interestingly, that both you and Jean-Gabriel focused on the word yet. I think yet is going to be a very important word for this program. Just then hopping across the Atlantic, Will, obviously it used to be said that if the US sneezed, we caught the cold 18 months later. You are obviously still going through your second or third stimulus negotiations, shall we say, and a program to try and get money into people's pockets. What are you seeing the impact of the virus over there, and actually the government intervention that obviously is incredibly large, given the numbers that we've seen.
Sure. Thank you, Andrew. I guess a couple of things. First, I would echo a lot of what my fellow panelists have been saying about very sector focused distress in terms of retail, in terms of travel. The other thing that was a feature of the early COVID world in the US restructuring market was businesses that either directly or indirectly depend upon access to the court system. When that got shut down, you saw very substantial disruption in the mortgage REIT market. The ability to foreclose drove so-called non-agency security pricing to distress levels that caused deeper levels of distress in some of the mortgage REITs, for example. The other thing, and just to sort of focus on the word yet again, I suppose, one other area going into 2021 that I think will be a very interesting area to watch, and I think a lot of people are focused on this, is as we come out of COVID, as blood starts to flow into parts of the economy that it may not have been flowing through, how do our choices change, and what restructuring opportunities arise? One area that I am very focused on is commercial real estate. Query, 1, 2, 3 years from now, are we doing a webinar like this over Zoom, or, Andrew, to your point, are we doing it live again? In terms of the U.S. stimulus, I think, for the most part, it has probably, it has had a effect that makes the U.S. look more European in terms of government policy. A lot of the direct payments to individuals, I mean, that frankly, that to me reflects more of a European style social safety net. So in certain respects, we're almost sort of catching up. By instituting these programs, we're really instituting a set of programs that looks, frankly, far more European, Scandinavian in color.
Yeah, and look, I want to switch gears quickly to obviously in the GFC, we all heard the phrase, what happens when the music stops, right? No one wants to be left without a dance partner and the like. But what happens when all of this, what some perceive as cheap money, as assistance, which is not really, we hadn't had to deal with the paying back of it kind of thing. But what happens when these programs are beginning to be wound down, withdrawn? And Igor, what do you think the effect will be in Spain? I mean, you mentioned moratoriums, you mentioned the end of furloughing, which has happened in various kind of facets across Europe. What happens when, we really just want the market to stand on its feet again?
Exactly. Well, on the one hand, it's clear that when these stimulus programs will end, the acceleration of insolvency will be clear. For instance, in Spain now, we are under a moratoria, so there is no chance either for creditors or even the companies to apply for insolvency. So of course, the insolvency proceedings are frozen. But as soon as these are lifted, it's clear that we are going to face a record of insolvency proceedings. We have estimations for this year of 50,000 insolvency proceedings. So it's going to be really a record. For this, we have 140 billion euros of stimulus from the EU funds, half loans and half direct subsidies. And of course, we will take advantage of that. But it's clear that as soon as too big assistance through eco guarantee loans that we had 100 billion euros of facilities that were state guaranteed by this public agency to provide liquidity to companies. Of course, ECOs has to be repaid as well and cannot be restructured. They are short-term facilities. So it's clear that the government has to do something about this. They plan to extend in order to avoid defaults. And another important factor is that we have another, let's say, the public conglomerate holding, which is SEPI, which has a 10 billion fund to rescue strategic Spanish companies. And we have a number of Spanish companies in the list that are in negotiations to be rescued by SEPI. We have Europa, the airline, Duro Felguera, Celsa. I'm sure that some of the names rings the bell, Globaria, Naviera Armas. So the important thing of this for future restructurings that we see in Spain is that you will not only, as creator, face banks, but you will also have ICO, you will also have SEPI, not only as creators, but also as shareholders. And of course, the restructuring with these companies, having all these new players, some of them public, will make really the restructuring process very challenging and much more complex to reach majorities. So I think that from a restructuring point of view, it's going to be challenging for all these new players, and also because we are going to face a period of record of insolvency and restructuring in Spain in this year and the next year for sure.
No, thanks, Inigo. As we then move through the pandemic, obviously we all have clients in our respective jurisdictions wanting to try and take advantage of situations, or even in some instances just survive. So what are we seeing as regards our clients? Many people perhaps listening to this call, their appetite for risk. Julia, what are you seeing in Italy as regards your clients and what they're looking for in terms of assets? And are they having to search for yield in different places? Are they having to go up the risk spectrum? Julia, you're on mute.
Yeah, sorry, I was struggling with my. Well, that really depends on whether we're talking about banks, financial institutions, or companies, like companies operating in the various industries, or if we're talking about specialized investors that are, they're familiar with the distress word in general. As to banks and financial institutions, at the moment, for example, they are continuing to support business in difficulty, mainly due to the guarantee schemes provided by the government. And so for this reason, at the moment, you don't really see an effect on the manner in which they invest. While if you look at the word of specialized distressed investors, they will take risk and focus on those industries that are facing or have been facing difficulties but are expected to recover, like, for example, the hotel and leisure sector, which, of course, tourism is a very important part of the Italian economy. And of course, it has been suffering, but it is expected that if you are prepared to wait for a while, then these sectors will recover, while others, for example, are not so attractive, like the retail business, because in that case, there has been a structural change. So, for example, if you try to segment the real estate market, hotels, people still have, the appetite to go into that type of risk, but less so if you're thinking about office space. Retail tends to be a no-go as such, while people are looking on some other type of opportunities, for example, in purchasing very well-known trademarks. So that's the way in which they look at risks. If you look at it from the perspective of a business, like an industrial company, business and companies, then again, as we said at the beginning, there have been new opportunities. I mean, people which were on the verge of insolvency, which were specialized in producing, for example, disposable paper, reconverted into the production of masks. So this is also a new opportunity, and now they are flourishing. So where other people suffer, there are others that take opportunities. So, and investors likewise tend to look at those movements, not really in the financial market, but more in, you know, going into the real economy to see the type of risk that you can safely take in this environment.
Yeah, no, and obviously we all saw what happened with logistics and you know, the delivery of goods online, and there's clearly a winner there, and that was a winner before COVID. I just want to switch away from COVID now, because obviously in Europe we've also had to deal with another macro event that's been going on for a few years, and that's Brexit. So what do we think are the restructuring implications in each of our markets post-Brexit? Phil, maybe I can, obviously given that it's the UK that's left the European Union, maybe we can start off with you and then get a European viewpoint of what's going to happen post-Brexit for restructuring.
Sure. Well, I think there's quite a lot to talk about here, but I'll keep it to 3 points, which I think are really quite significant. One is the impact of Brexit on English or UK schemes of arrangement and the restructuring plan. The second is the impact on the ability of EU restructuring and insolvency proceedings to compromise English law debts. And the third is the impact on the recognition of English or UK administration proceedings. So just starting with the scheme or the plan, I actually don't think that there is going to be a huge impact on schemes and plans from the 1st of January this year. And the reason for that is that although the UK is not party to the EU insolvency regulation anymore, schemes never relied upon the EU insolvency regulation for their recognition abroad. And the only piece of EU legislation that English schemes have relied upon for their effectiveness is really the Rome I regulation. And what Rome I does is it requires that contracting states, and that includes the member states, respect the choice of law that parties have made in their documents. And not only the choice of law, but also the way that those obligations are then discharged or varied. So the net effect of that is that because Rome I will continue to apply to English law contracts, as you know, it's not a exclusively European concept. It applies to any law, whether or not it's a law of a member state. The impact of that is that, provided that you have an English law debt being compromised by an English scheme, Rome I should operate to require member states to recognise the effect of that scheme on that English law debt. And the problem is where you don't have English law debts, where you have other governing laws involved, and that's why we've seen a number of English schemes recently convert the debt prior to the scheme into English law. So you know, we've seen, for example, the recent case in Hertz, where the notes were governed by New York law, and it was converted to English law through a consent solicitation before the scheme started. And that's been the case in many cases over the years, even before Brexit. So I think the other possibility where you have a debt that's not governed by English law is to use the US Chapter 15 proceeding to recognise the scheme, and that also, because the US Chapter 15 has global reach, we'd be looking to solve the problem and implement a Chapter 15, and that should give the scheme more international recognition, international effectiveness, I should say. So that's, you know, to our scheme stand. And coming to the second point, the second question is the other way around. If you have a European insolvency or restructuring process and it's dealing with an English law debt, is that going to be effective in the UK? And that there is a big question mark going forward with that, because that we have to have this quite old rule in the UK, which was relevant before the EU insolvency regulation came in. That meant that you can only use an English insolvency proceeding to compromise an English law debt. It wouldn't recognise, for example, a French or German or Spanish or Italian proceeding as being effective to compromise that English law debt. And that went away. That went away as a concern for so long as the EU insolvency regulation was there and the UK was party to it. But that is now back as a major concern. And I think there are a number of solutions to that. Potentially, one is to try and overturn that rule, which is possible, but probably not ideal. Secondly, is to have a UK parallel process of some sort, which again is not ideal because it increases the cost. And the third is to look to Will again for help and to get the European process recognised in the US, and that might also help the ability of that process to be recognised and the effect of that process on an English law debt to be effective in the UK. So those are three potential solutions. And the third issue I just wanted to come to is probably one of the most difficult ones to solve, and that's actually the recognition of administration proceedings in the EU. And I think that's going to be quite difficult because we're effectively back to the pre-EU regulation position where recognition is on a member state by member state basis, and different member states will have different approaches and different means to recognise those proceedings. And you'd have thought that hopefully with most member states will take a reasonable attitude to this, and will see that English insolvency proceedings administrations will be recognised in different states. But we don't know that that's going to be the case, and some states have incorporated the Alston trial model law, others haven't. Some have rules of comity that might apply, and I think that takes me nicely into turning to my European colleagues on the panel to give their views.
Okay, thanks, Phil. I know. Maybe we'll just deal with Eva. I know we're running up against time, so you hit the UK point, and I think Phil's plea was for reasonableness as regards common mutual recognition, and perhaps even mention the Lugano Convention as well, because clearly we're still not able to take advantage of that in the UK at this point.
Yeah, I would assume in Europe, and I can actually speak then for Germany, the Brexit will leave us with a rather uncertain situation. For administration proceedings, we will probably rely on national law, how we recognize foreign insolvency or administration proceedings. So we are not there with a European answer, I would assume, given the fact that the UK dropped out of the EU regulation of foreign insolvency. If it comes back to a scheme, and I think that's the more, from at least in our restructuring practice, the scheme is the proceeding where most of the clients look at the moment. How do we deal with that? Very often with English law debt being part of the restructuring, and whether that will be enforceable or how we best enforce it. And Lugano could be one solution, but that's not yet through. Or we actually deal with Rome 1, or we deal with our civil procedure code. And again, there are a couple of questions which are really legal questions. And for the time being, our tendency is to say it's a rather uncertain thing to do at the moment, knowing that if there was English law debt, that we need to actually go to England as well for the English law parts of the restructuring. So it's a bit of a complicated situation at the moment, and I do hope that Europe quickly finds an answer to that.
No, thank you. And look, it seems as if every country in the world, I mean, given that the problems that we've discussed with COVID as well, is trying to either implement, adopt, or try and elaborate on some kind of pre-insolvency regime to deal with the problems that will obviously come. We mentioned the word yet, obviously will come through the post-pandemic phase. We've got the restructuring directive. I mean, maybe just flip back to you quickly, Phil, and then what your view is of the pre-insolvency regime, and then we'll come back to Inigo and the others for a response from Europe as well, for them to just briefly tell the audience where their respective countries are as regards to pre-insolvency regimes.
Yeah, well, you know, the pre-insolvency regime, the directive, the restructuring directive in particular, I thought was a great initiative, and you know, I'm really pleased to see the uptake that's been present amongst European jurisdictions on that, and the way that that's been implemented is, or was due to be implemented is really encouraging. From the UK perspective, clearly we don't have an obligation to implement it, but we have implemented parts of it, at least in relation to the new Part 26A scheme plan, restructuring plan, which is, you know, people call the super scheme. And you know, the main feature of that, without getting into masses of detail, is the cross-class cram down, which is an incredibly useful feature, which wasn't present previously. You know, the ability to cram an entire class where that class is actually in the money is a really useful feature, and I think that it's had so far really positive uptake. You know, we've seen plan being used in Virgin Atlantic, Pizza Express. We've seen the first cram down in Deep Ocean recently, just last month. And there are upcoming plans for Gate Group and Premier Oil, which would be interesting to follow. So I would have thought that the restructuring plan with this feature will become really the main restructuring proceeding that's used in the UK, where you have any dissentient classes or any prospect of dissentient classes. And you know, it will really replace the scheme, I think, as the main means of executing restructurings. There are some issues, I think, where you might not see it, and you might see people still using the scheme, you know, where you have all the classes signed up and locked up beforehand. There's no point in doing a restructuring plan. There's a little bit of extra uncertainty involved, and you know, transactions where certainty of execution is really a premium, you know, really critical, such as you know, some structured deals. I think we might still see the scheme being used over the restructuring plan. But you know, it's going to be a big feature, and I think I would be you know, certainly expecting it to be used more and more as the year goes on.
Okay, thanks, Phil. I'm just very conscious of time. I really want to get to the next topic as well, which is how shareholders are treated. So I can imagine a lot of the audience will want to know whether there's any forum shopping for how shareholders might get treated in kind of restructuring. But before we move on to that topic, which I think is very interesting, why don't each of you describe very briefly what your pre-insolvency regime is? Julia, perhaps you can just describe what Italy has, because I understand obviously that the restructuring directive has not yet been implemented in each European country, but at the same time you might have national laws that already implement a form of it.
Yeah, you're right. I mean, the EU Directive 1023 on preventive restructuring frameworks has not yet been implemented in Italy. However, we had even before the directive was issued, we implemented a reform which is called like it's a completely new insolvency code, and it already complies with many of the provisions of the directive. So maybe we will need certain amendments, but the bulk of the structure is already there. So, for example, early warning tools that are already provided, that are provided by Article 3 of the directives. We already have what is called an alert mechanism by the corporate supervisory bodies when they detect signs of a distress or a crisis, and then also an external alert mechanism that must be implemented by certain qualified public creditors, such as the Italian Tax Authority, the National Security Institute. And then if the directors of a company do not take appropriate action within reasonable time, Then there is a mechanism where the supervisory body need to file a notice to a specific new body which has created, which is called crisis composition body. My view is that those tools are not incompatible with the directive and probably don't need amendments. As to preventive restructuring framework, we already have a number of restructuring proceedings that are available when there is the likelihood of insolvency, because we have a composition with creditors called concordato preventivo in Italian, debt restructuring agreement, and certified reorganization plan. So I think those already comply with the directive. As to another point of the directive, for example, the formation of classes as provided by Article 9 of the directive, we already have a mechanism that allows the formation of classes. We probably just need to impose these as a requirement. I'm thinking about formation of classes in restructuring plans or other tool. For the appointment of receiver and judicial commissioner, the Italian bankruptcy law, as it is now, as it is in the new code, the new insolvency code, this provides for a compulsory appointment of the judicial of a judicial commissioner in certain proceedings. So this provision might need to be amended in order to comply with the directive. So my overall view is, yes, we need to make some changes, but not that much.
Great, thank you. And look, we keep on hearing that COVID is an accelerant, right? It's going to, it's fast forwarded changes and stuff like that that's going on. So hopefully what can come out of it can perhaps be a more coherent, unified pre-insolvency regime across continents. Inigo, briefly, what's Spain's pre-insolvency regime?
Well, in a very similar way to what Julia was explaining for Italy, in Spain, the directive is not fully implemented, have to say, but key parts such as the Spanish scheme or homologation and the pre-insolvency tools are already regulated. So we have already those and ready for this new wave of restructuring. As future tweaks and amendments in Spain, we anticipate three. One would be what is interim financing. Seems that it will be a similar regime to the new money, so 50% will be privileged. But we don't expect here radical changes, and we don't expect to have regulation of premium financing, for instance. The second one will be the change of treatment for the equity crampdown. We don't have such mechanism now in Spain. We think that either will be an increase of personal liability for those shareholders that oppose to the restructuring without reasonable cause, and therefore restructuring are blowout, or even maybe there will be a separate new class of equity holders to vote. That will be probably the two choices that we have. And finally, we will also have a different approach to creditor classes. I think that our approach will be more similar to Chapter 11 and English scheme in the next amendments to our insolvency law. So creditors agreement will be relevant, not just the credit ranking as set up in our insolvency law. So those are pretty much what we anticipate for the next months.
Thanks, Inigo. And I'm going to come to you, Jean-Gabriel, because then I'll finish with Eva, because I think Eva, Germany has adopted the directive. But Jean-Gabriel, pre-insolvency regime in France?
Yeah, we are actually in the middle of discussion currently, so it's quite, everybody is lobbying currently and answering the state consultation, which is currently in progress. We have actually already a pre-insolvency and quite detailed regime, conciliation and safeguard. The main question now is which of those regimes will actually include most of the provisions of the EU directive. And currently the state is looking at the accelerated safeguard, which was quite rarely used. But that accelerated safeguard could be used as a tool actually implementing the EU directive. So there are plenty of discussions currently. plenty of discussions about the ranking, about new money, about cross-class crackdown, about the role of shareholders. We may discuss that in a few minutes, but that's typically the discussions we have currently in France.
That's great. Sure. And so, Eva, if you can briefly just say what Germany's done in terms of that directive.
So we've introduced for the first time in our history a pre-insolvency law. It's quite new, and we have been struggling with it for the last 6 weeks. The idea of the government was to introduce it to cover the COVID crisis as well. So there was quite a rush in the parliamentary system. So we passed it through within 3 months. Normally, a new law of that size takes a year. So that is one of the responses of the government to the COVID crisis. Very new is shareholders are included. So in that pre-insolvency, not only the debt and the creditors are included, and they will actually vote in classes, but two things which are completely new in Germany. The one is contracts, in particular syndicated loans, Schuldschein loans with a number of creditors may not only be terminated or the debt is short or decreased, but it may also be changed. So you can change interest rates, you can actually change security rights. So that's entirely new to the system. And for the first time, shareholders may be part of that restructuring scheme. So you can actually take away their shares, withdraw certain shares, or take other corporate actions as part of the restructuring scheme. So that's completely new in Germany and, of course, rather criticized. But that's what it is.
Excellent. Well, look, that's a very opportune time to turn to shareholders, because clearly I think Will, I wanted to take your view on all these European countries, including the UK, that's trying to compete to make themselves as attractive as possible for restructuring. We obviously dealt with pre-insolvency regimes. I wonder if you can touch on that, and at the same time then switch gears to go into our shareholders discussion to talk about the attractiveness. Obviously, we have New York law. We all know how attractive it is for restructurings. We've got English law, and now you see a wealth of European countries, including national laws, really trying to play catch up, I guess. But I wonder if you could just touch on what you've heard.
Sure. Certainly in the U.S. for a long time, we've had a fairly well developed corporate restructuring regime, principally with Chapter 11, that has some fairly clear rules that have, essentially the need for a separate pre-insolvency regime is obviated, in my view, by that, simply because, most reorganizations that wind up in bankruptcy wind up being negotiated prior to the filing based upon those, what are fairly clear and well understood rules. One note, I was very interested by what Phil had to say earlier in terms of the UK's new plan legislation. He focuses on the cross-class cram-down, which is obviously a feature of US insolvency. And, Andrew, to your point, makes it more competitive, if you will, with a US style restructuring. One, I think, opportunity on the European side is, my understanding is that one of the rules that is sort of bedrock to US Chapter 11 practice is the so-called absolute priority rule, where, for instance, shareholders, absent their consent, absent the consent of a senior class, shareholders cannot receive anything in a restructuring until the senior classes have been paid in full. That may well become almost a common law-esque feature of English plan restructuring as well. My understanding is it is not part of the statutory regime. And to me, that's sort of the foot point on the shareholder question that you posed, which is one thing that US restructuring is not friendly towards are shareholders. The absolute priority rule acts as a fundamental barrier to getting value to that class. Now, we have developed certain workarounds in certain instances, but generally speaking, a creditor in a U.S. side restructuring is going to have a statutory priority that is going to be respected in court in almost all cases. And so as we sort of look forward into 2021 and beyond, I think one of the things we want to be talking about are where are opportunities on a cross-border basis. Certainly, I think that there may well be some opportunity to, from a shareholder's perspective, to look at a restructuring that might ordinarily occur in the U.S. in the main case, and basically say, look, I don't like this feature of U.S. law. I may want to go shop for another jurisdiction, with the idea of coming ultimately back to the U.S. after I have it in place and seek, to a point that Phil raised a number of times, Chapter 15 recognition. That will create a very interesting dynamic for the U.S. courts about whether or not, as a matter of Chapter 15 law, we would recognize a restructuring that does not include the absolute priority.
Thanks, Will. Phil, do you want to add anything to that?
By mute. Yeah. Hi. Yes, I will. That's thank you, Will. And that's really, it is really interesting the way that we've chosen to approach the absolute priority rule, the concept of absolute priority and shareholder priority, or creditor priority of the shareholders in the 26A plan, because, as Will said, rather than set out an express absolute priority rule, what we've done is say, well, you can cram a class provided that they're no worse off than they would be in the relevant alternative. And the relevant alternative is in most cases it can change depending on what would be the most likely alternative, but in many cases will be a liquidation of the company. So in a situation where you have a secured class of creditors and an unsecured class and equity, and in the liquidation only the secured creditors would get any distribution, then in theory the legislation says nothing about how you divide the pot between the unsecureds and the shareholders. Now, having said that, it's all subject to the court's discretion, and we've seen the court approach in the deep ocean, in the one cram down that we've seen in deep ocean. The court did talk about imposing a requirement of fairness and into the discretion, and to look closely at how what the court called the restructuring surplus would be divided between the classes. And by the restructuring surplus, what the court means is the value that's generated or preserved by the restructuring. So effectively the difference between that liquidation value and the restructuring consideration, and in particular, I think the court's going to be looking at questions of to what extent how has that restructuring surplus been created? Is it coming from the value that should be going to a particular class? Is value going to shareholders when it's effectively being appropriated from another class? And I think the court will be mindful of those. So I think Will was very astute to mention the prospect of there being a potential common law absolute priority rule, but it's going to be flexible. It's going to be flexible enough to allow value to get to shareholders where it's appropriate to do so, and where there's a good business case for doing so. And likewise, I say shareholders, it applies for any class that's being crammed down, or where there's another class potentially getting something that they wouldn't get in a liquidation, or some different distribution. So potentially the distribution can be flexible enough to account for the commercial realities of the business and what's going on. I'm sure we're going to see situations where value is going to equity, value is going to management, value is going to trade creditors for sure, where they wouldn't be getting that value in a liquidation, and there are other creditors, other classes ranking ahead of them who are not being paid in full. And I think what we'll also see is probably a gradual sort of creeping as people try to get more and more value to sponsors, and we'll see that being tested in the courts as the case law on the restructuring plan progresses.
Okay, I'm very conscious. I want to get to our last question. I just remind the audience, if you've got any questions, please do use the Q&A button that you see at the bottom of the screen. Eva, do you just very briefly before we hit our last question, how are shareholders treated in Germany? Do you want to add anything to the discussion that you've heard from Will and Phil? You're on mute.
Sorry, yeah, can echo. So far, shareholders are, of course, are the last place in the priority. Creditors, of course, come first, and that will remain. On the other side, in particular in the pre-insolvency regime, as I just said a moment ago, that the shareholders are part of the scheme or of the pre-insolvency plan is new to Germany, and so there will be part, and we can. And for the first time, we have a regime to do a debt to equity swap without their approval, or have them into a class, so we can force them into the scheme rather than having them at the last thing. But for all these restructuring plans, we couldn't do that without their consent previously. But even because they were always the ones who say, we are the last one in the row, but if you want my consent, what's in for me? That has changed. They are now part into part of the new scheme, which helps us with overcoming that hurdle.
Right. Look, I want to ask one more question before we finish. I'm very conscious we're hitting the bottom of the hour. So I want to focus on a couple of takeaways for our audience. I think our audience has been very patient in waiting to get the present at the end of the party. As we gaze into our crystal balls, we mentioned the bid and ask price being divergent. We mentioned how we can unlock assets. We're obviously gone through a very big macro events in a low interest rate environment. We're late cycle. If any of the audiences out there hoping for some gem as to how we can unlock this assets, we all know that there's a wall of money out there chasing assets. We've mentioned the word yet a number of times. Maybe the timing has to come yet. We see in the UK a number of what I call friendly money, NAV type lending, restructuring money that perhaps the banking markets don't really want to get involved in terms of restructuring, but that restructuring money is there for people that want it. But it seems to me that there really is just a lack of product at this time. So to you all, as you gaze into your crystal ball, what do you think 2021 will be like for our clients and their search for transactional activities? Maybe I can start with you, Will, and then we'll go around the house very quickly.
Sure, just very quickly. I mean, I think that as I come back to the word yet, I think, ultimately you have to be looking at how do you view long-term asset values, and where is demand going to flow into the economy as we come out of COVID. I think that there's an element where there have been areas of the economy that have essentially been shut off. I'm very interested to see what happens when the blood starts to flow back to those parts of the economy again. You may well get a very different look from banking institutions, for instance, in terms of not being quite as favorable and generous on workout terms, and they may start further enforcement proceedings. I think that is a likelihood. You've heard from, frankly, all panelists today focus on the fact that I think it's been a surprise to everyone how few restructurings there have been during the course of COVID, and I think the banking and lending response to that has been a big part of it.
No, thanks, Will. Inigo, do you have anything to add from Spain? What's going to keep you up as we go through 2021?
Yeah, well, Spain learned from our previous financial crisis, and we are now much better prepared to face this one. Our insolvency regulation has more effective restructuring tools. No doubt that companies will suffer this lack of liquidity, particularly when the financial aids terminate. So they will need to look at the private debt market and foreign investors. We expect banks and funds working together in these processes in Spain. We see also banks and the state through this Spanish public agency in the capital structure of the Spanish company. So I think the restructurings will be much more challenging to achieve. And from the macro perspective, honestly, it doesn't look very promising for Spain. But on the other hand, in terms of restructurings, refinancing, distressed assets, lending platforms, real estate, I'm sure it would be very active with a lot of international fund flow into Spain to cover this gap. So I'm pretty optimistic on the transactional side.
Thank you. Look, we don't have time. We've run out of time. There's one question about COMI, which I'm going to ask in a different way. You're not allowed to say your own country, but the question surrounding COMI would be, where is the best place to go and get your deal restructured in the globe? And you're not allowed to say your own country. Eva?
So far, and of course, because we are all in an English audience, which should probably say the UK, but given for Europe, where we looked a lot into the new law of the Netherlands. So none of us is from the Netherlands, but that is where Germany took a lot of inspiration from, because their new law is probably a rather modern and convenient law. So that's how we understood it from our Dutch colleagues.
Anyone else? I'm not going to ask Will and Phil because they'll both just say the UK and the US. Look, I'm conscious we've hit our hour mark. I do thank you. I think it's been a wonderful discussion. It's not easy to do a hop and a skip across so many different countries, but I think we achieved what we set out to do. Thank you to the audience for staying with us. I'm hoping that you've picked up some interest. And I think my takeaway is that, we are still going to see a lot more activity in the restructuring space. I think we all knew that, but the very fact that we've seen a decline in traditional restructuring up until now leads me to believe that we are going to see a lot more activity as we come out of this crisis. So we produced a guide. All the people on this call, aside from Will, because we focused on Europe, all the people on this call contributed to it, amongst others as well. You obviously, there's 23 countries there. You'll get a copy of that guide if you haven't already had it as an attendee. And please do, if you've got any questions for anything that you heard today, if you've got any questions for any of the panelists having received the guide and want to talk about a particular area of enforcement, then please do get in touch. I do believe that's all I have to say. I don't have anything else other than thanks for joining us and stay safe. Thanks, everyone.